afternoon. I'm Felix Chen. I'm an associate professor at the Faculty of Law of the University of Hong Kong. It is my honor to introduce our distinguished speaker, Dr. Hin-Yan Liu. He is an associate professor at the Faculty of Law of the University of Copenhagen. Dr. Liu specialized in exploring the challenges to legal and regulatory thinking brought about by artificial intelligence and other new and emerging technologies. Dissatisfied with doctrinal attempts to accommodate revolutionary technological change, he has pioneered the concept of legal disruption that pits the law as just another moving part relating and adapting to change. So today he will give a talk on artificial intelligence and legal disruption. Without further ado, I would like to invite Dr. Liu to discuss this interesting topic now. Thank you.
Okay. Thank you very much, Felix, and thank you very much for organizing this talk. And so I understand that in Hong Kong, ordinarily you have a speakers are expected to have a presentation to talk through. Unfortunately, I haven't done this for basically as long as I remember, and it's sort of intentional because like the way I see this talk is as a way of kind of throwing out ideas, throwing out loose ends, and seeing whether the pieces of the puzzle that I have connect with those that you have, and maybe we can sort of engage in a dialogue, a conversation, a sort of very critical discussion. So I'm just going to kind of talk loosely. The talk is also loosely structured, and I've left plenty of time for discussions and comments at the end. I should also note that if anything of this talk interests you, I'm easy to find. If you just type my name into Google or some other search engine, then I pop up. Please do contact me, and you'll also find the publications that this talk is kind of based on. And so my main concern is about sort of new technologies. Raising questions that we're not really necessarily responding to, talking about, or even sort of we're not even aware of this, the actual sort of the breadth and depth of the potential problem space, as I like to call it. And so how do I mean by this? Let's retract way back to sort of what I call like orthodox legal sort of examination, as it were, of AI and other emerging technologies. And obviously this is no disrespect to those colleagues who are also working in these areas. It's just my sort of nudge, my push that, to get you thinking about sort of, other problems or sort of more fundamental problems that are sort of slightly more subtle. Okay, so let me wind back. So before legal disruption, I think most legal research sort of at the intersection of new technologies and the law sort of focus on sort of actual legal problems, doctrinal problems, right? So how this tends to work is you have the law on the one hand, and you have a new technology on the other hand. You kind of clash them together, right? And then at that clash, out drops particular problems that are recognizable by the law. That we can discuss with legal terms in terms of legal principles and processes, and there's particular legal problems that fall out, right? And so I'll give you 4 examples of this just to sort of get us started, right? So the most I guess internationally visible, at least several years ago, legal question sort of surrounding artificial intelligence was the military applications, right? So, for example, autonomous weapon systems that once activated can select and engage its own targets without further human intervention. Those kinds of hypothetical technologies, at least back when we were talking about many years ago about those, is that okay? So if there's unlawful violence, who's responsible, right? And who's responsible for what, right? So that's that's the setting. You can take this kind of question to a civilian sphere, right? So with the prospect of autonomous vehicles, like sort of self-driving cars, however you wish to call these, if they cause sort of accidents, injuries, sort of like other forms of damage, again, who's responsible for what? How? What are the remedies? Right? So that's a sort of package around autonomy, control, responsibility, those sorts of questions, right? A slightly different example is, okay, what happens if AI applications produce creative works, right? Then, how does IP law address that? Like contemporary IP doctrine, as far as I'm aware, is sort of focused very much on, like natural persons sort of holding IP rights. But somehow the prospect for AI applications to produce creative works, whatever that means. Let's sort of keep the definitions out for now. Like how does IP law like address this, right? So that's another example. And yet a different example is, okay, so what happens about with algorithmic decision making, right? So like sort of algorithms that make decisions about you, right? It seems somehow that there are questions of transparency, of transparency and opacity, of sort of accountability, of procedural questions, all these sorts of things, right? And so each of these four examples, and I've just kind of sketched them very loosely, sort of present some discrete legal questions, right? So who's responsible, how, who gets the rights and when, and also like, okay, so like how do we sort of control or somehow contain decision making, essentially. And so these are interesting questions, but I think the main problem I find about this is that they're kind of unsatisfactory in a sense, and they're unsatisfactory because for me at least, it presumes that the law is immutable, right? Okay, let me qualify this. The law is immutable in terms of its principles and processes. Sure, there's certain types of accommodation that new laws that are sort of introduced, or sort of new interpretations that kind of somehow soften the edges. But essentially, the sort of legal principles, the legal paradigm itself is somehow immutable, right? So there's a presumption that there's autonomy and control and responsibility, right? There's a presumption of rights and obligations. That there's the presumption that there's some sort of answerability in terms of power and decision making, those sorts of things. Right, and so because these are legal questions, they're also solvable actually, I think, relatively straightforwardly in terms of legal doctrine. Right, it's simply about setting up a legal position. Right, so all one really has to do, for example, with the IP example, is to say, okay, well, wait, okay, right now it's only human beings, natural persons. Okay, we can extend it to AI applications and see what happens. Or simply, okay, it's only human beings, that's the legal position, right? You can answer this. Or like, with like autonomous vehicles, right? Okay, so in Denmark, for example, there's strict liability for traffic, right? So people drive very carefully here. But you could simply have that as a, okay, if you put a self-driving car on the road, you're imposing a risk on society, therefore you're responsible for it regardless. Something like this, right? So I guess what I'm trying to say is that because they're legal doctrinal problems, they're also very straightforward legal doctrinal answers or responses. So somehow to me that doesn't, that's nice because it sort of ensures legal continuity, certainty, predictability, all of these things, right? And it allows us to be able to operate in the world. Like I understand that in terms of coordination and sort of like knowing what will happen, what the repercussions of particular actions are. But from a sort of like a more abstract or sort of theoretical kind of stand, I think that these kinds of like orthodox approaches kind of cut out the possibility of being able to use these new technologies and what they bring as a way of reflecting upon the legal system as it exists, but also it shuts out the possibility of thinking about, okay, well, what exactly are these new technologies doing in terms of not only law, but in terms of regulation more generally? So let me sort of fit this into the algorithmic decision making, right? So for some reason, like having an algorithm make a decision about us, throws us off, right? It's just like, well, it's not a person. We don't understand. We don't necessarily understand how, like, the information it takes in, the processes, underlying that decision making, like all of these sorts of things, right? And somehow that makes us very, very suspicious, and it becomes a problem. But if you actually sort of think about it, like human beings, we're actually, we pose the same problems, right? Like, I don't have access to all of my thoughts, motivations, and anything like this. And I certainly don't have access to another human being, say a judge or an administrator, making decisions about me. I don't have access to that, right? It's the same black boxedness as an algorithmic decision making process would be. But somehow, because it's packaged as a natural person, and because we're used to this, it doesn't sort of qualify as a legal problem per se. But I mean, the point is, if you have the capability of a sort of algorithmic decision-making process, it somehow allows us to then reflect upon the current configuration and why that's justifiable or not, things like this, right? So that got me sort of thinking, right? Okay, I mean, a lot of legal problems, legal solutions, it doesn't feel satisfactory. What is actually going on here, right? And so this is sort of the concept of legal disruption that I've been working on now for many years. What exactly, what's the innovation of the technology, right? It's not the technology itself, it seems, because like what's the difference between a hammer and an AI? People say it's autonomy. It's a new form of discretionary autonomy, right? It can decide, inverted commas, what to do among a range of options, something like this. But what we have to remember is that the autonomy framework is only one way of framing these discussions, right? So why do we think about AI applications as something pseudo-human, as something that's capable of discretion, of decision making, something like this? Sure, that's a model that we can adopt, and somehow it fits conveniently with legal discussions, because I mean, at root of all those examples that I gave you is that AI applications occupy this liminal zone, this kind of ambiguous space between agents and objects, right? So the law is used to sort of having this mutual exclusive kind of view of the world. That there are entities that are agents that operate in the world with autonomy, and there's objects where they're just kind of passive and they're operated upon. AI applications somehow fit in between, like they have technical capabilities, but a lack of legal sort of responsibility or recognition, something like this. And as a result, they sort of have this ambiguous kind of liminal kind of existence in the legal system. And that's at root of many of these sort of orthodox legal questions. But at the same time, what I think is possible is that we can actually also kind of reframe AI applications through other ways, right? So why don't we think of AI applications actually as more of a network or as a complex adaptive system, right? And so if instead of thinking of AI applications as sort of singular autonomous agents, but actually as sort of deeply collaborative kind of sort of swarm-like, like a swarm-like kind of entity. I know that swarm and entity, they're not exactly they don't fit as it were. But if you frame it like that, then sort of concepts such as like emergent outcomes and sort of come to the fore, right? So sort of things just happen, but responsibility is locked out. It's not a choice. It's just interaction, right? But the thing is, I think at least that kind of framing is as valid as the autonomy agency framework. But the problem is it's much more difficult, especially for people working in the legal area, to get to sort of get a handle on, simply because agency, autonomy, control, responsibility, all of those things completely fall out of the way. And again, if we use AI applications as a way, as a mirror to sort of reflect upon our contemporary view of how law works in a sense, it's just like, well, wait a second, isn't this sort of complex adaptive sort of framework also a way of understanding how we work absent the technology as well, right? So why the focus on on these sort of legally recognizable questions in a sense? So that's sort of one way of sort of thinking about it. So AI applications, they throw up new capabilities or new affordances, as I've termed it in the literature, right? New affordances, new capabilities, which then sort of change like ways of operating in them. And so one of the ways that I'm thinking about this is, okay, so instead of thinking law as the sort of be all and end all of regulation, right? So like instead of recourse to the law always, we can actually think of AI applications as opening up the sphere, of the arena of different ways of doing regulation, in a sense, right? And so a friend and colleague of mine, Roger Bransford, has sort of set out like 3 different generations, as he sees it, of the regulatory environment. And I kind of used this framework a lot to sort of build off of, right? So in the first generation, in the first generation of the regulatory environment, it's very much reliant on normative signals, right? So like stop signs, red lights, like stuff like that, So you're able to do everything. There are sort of signals, in the environment that tell you you should do this, you shouldn't do that, and I guess attendant with that there are sort of incentives and punishments that attach to this, and that's very much the realm of the law as is, right? You're free to operate within the laws of physics, right? But there are certain costs and benefits to behaving in certain ways. Fine. But what AI does, I think, really interestingly, what cyberspace and then AI and XR, extended reality, which I'll get to in a moment, what these technologies allow actually is a sort of more infrastructural, technological management or architectural way of regulating. So, Larry Lessig was the one who sort of termed like code as an architectural way of regulating, right? So there are certain things you can and cannot do. If we go back to Roger Bransford, for example, right? You can use technology as ways of managing behavior, right? So you can immobilize golf carts to stop them driving onto greens, for example. Like things like this. And so with technological management, it's like, wait, there are things that you can and cannot do. The undesirable is collapsed into the impermissible, impossible, right? It becomes impossible to do those things that the regulators don't desire, in a sense. And I find that idea very interesting because like that's kind of what cyberspace is. And the more technology is infused into our world, the more opportunity for this type of architectural regulation, this type of technological management. But what I find really interesting, and this is kind of like sort of skewing into my latest article, which is coming out in a few weeks, is that if this architectural kind of regulation, if it breaks, if it fails, something like this, then suddenly people are free again and they have to rely on normative signals, right? To know how to behave, right? So if the regulatory environment suddenly, like, how would you say it? If the bands break, then the sort of the regulatees are able to act again freely, right? So in the third generation of the regulatory environment that Roger sets out, it's the incorporation of the regulation directly into the regulatee, and therefore sort of it doesn't matter if the actual sort of regulatory environment breaks. It's actually the regulation is sort of incorporated within the regulatee. And this is a legal disruption that I see happening with artificial intelligence specifically, but also with extended reality. So let me, in order to sort of illustrate this point, let me go back to the idea of algorithmic decision making. Remember, so you have an algorithm that makes a decision about you, right? In a certain context, in a certain setting. And so so this is usually the concern, right? That this sort of unaccountable kind of opaque black box algorithm is making a decision that affects your life, but that's kind of like those sorts of questions are relatively sort of well rehearsed and sort of relatively well contained within sort of like administrative law procedures, human rights principles, stuff like that, right? But what happens when those AI applications actually interfere with your decision-making processes? So as soon as I say something, it's like, oh yes, right, of course. I mean, there are these sort of publicized Facebook experiments that have manipulated the emotional states of its users, like things like this. And it's just like, okay, intuitively, I think you get what I'm saying, right? That, instead of the concern of algorithmic decision making sort of as an external entity making decisions about you, it gets in your head and affects your decision making processes, right? Or affects your emotional states, your behavior, this sort of thing. And that fundamentally is a different type of regulation, right? So I think that Roger's kind of right in the sense that in the third generation, with certain technological affordances, capabilities, regulation can sort of bypass this sort of fuzzy normative framework. It can also bypass, like setting out your environment in which you're sort of still a free agent, but sort of constrained in terms of possible and impossible, to simply, this is how you behave. And so I see this as almost the most pernicious challenge in terms of legal disruption, right? Because the problem is, it seems as though it's the agent actually sort of making the decisions or or behaving in a certain way, and the law tends to facilitate this, right? So the analogy that I like to make is it's sort of like a virus injecting an RNA into the host cell and sort of getting the host cell, like hijacking its metabolism and machinery to sort of produce more copies of the virus. It's something like this, right? It's just like, oh, well, the cell is sort of producing more viruses. That's kind of what it wants, in inverted commas, to do. I think that's how the law sees it, but it fails to see the sort of external influence in the internal sort of processes in the first place. So that's how I see that like AI applications causing like a fundamental legal disruption. It allows regulators to do regulation in other ways than the law or than in architecture or technological management. I don't think people are talking enough about this kind of shift, right? I think that's okay. Fine. You have AI. It sort of meddles with you. The sort of other prong that comes from extended realities. So like extended realities are sort of virtual reality, augmented reality, mixed or mediated realities. I think with a sort of audience like this, that we're kind of like we have a sort of good understanding as to what this is. And so how does XR feed into this conversation, right, about sort of AI and legal disruption? And so the way I see it is that XR actually fabricates or mediates our environment in such ways that also are capable of interfering with your decision-making processes, or in terms of your sort of emotive states, all of these sorts of things. But it adds one, I think, quite crucial addition, right? And this is, how would you say it? This is actually just sort of like mediating your sensory input, right? So in order to make this argument, we have to sort of take a sidetrack into Anil Seth. He wrote a book, Being You, and has been sort of talking about this sort of idea where human perception is not about sort of it's not like a sort of video camera which simply records, but it's actually an error minimization process, right? So you kind of predict what happens, and then the sensory input sort of filters, calibrates your prediction to what sensory input comes in, right? And so it's sort of hallucination that's anchored in reality. That's his understanding of perception. And so tethering this idea with the sort of capabilities and the affordances of extended reality suggests something along the lines of being able to manipulate your human perception, right? Does this make sense? So humans will sort of predict to see something, and by being able to tweak the inputs through mediating your reality or in virtual reality, right? You will then be able to sort of actually affect what people perceive far more upstream than what I was talking about before with AI applications interfering with our decision-making processes, right? So AI makes interferences in our decision-making processes, but somehow we might be able to be aware of this, right? But but what I'm saying with XR is that it's further upstream. It affects our sensations. It affects sensation, which then sort of percolates into perception, which then also kind of is capable of shaping your very being, because you're essentially some of your experiences, right? That's one way of putting it. And so with AI and XR, it seems as though these new technologies end up being able to sort of enable regulators, or at least those who control these technologies, to be able to, how would you say it, bypass law and legal regulation, bypass other forms of regulation, and just cut to the chase by impacting actual sort of just human behavior in a very, very direct and I would suspect, although I'm not obviously no expert, in a very sort of surgical and precise sort of manner. And what is I find is very, very sort of scary about this kind of prospect is that the possibility for pushback is gone, right? So with the progress from each regulatory generation, the possibility of the regulatee sort of pushing back diminishes, right? So in a sort of regulatory environment with normative signals, it's possible to disobey those signals and to do something else, right? With the second generation, with technological management or architecture, it's not possible, because it's simply impossible to do those things that are undesirable and implemented in the system, right? But in the third generation, even thinking or feeling, against the wishes of the regulator, that itself, I think, is gone, because the very fabric of your being is changed, and so I realize that this is not a legal discussion, right? But I think that this is exactly the point in legal disruption, is that it's not a legal disruption, because these sorts of questions are very, very difficult to sort of identify and articulate in sort of legal terms that can sort of then be like, okay, well, there's this problem. Okay, these are the sort of legal principles. This is the precedent. Okay, these are the likely outcomes, and it's probabilistically it's likely A rather than B, something like that. It's not that kind of question. It's operating at a much more sort of fundamental level. And so, and I realize I'm running a bit out of time here, but so I'll end with this. So I guess what I'm fundamentally worried about is that legal, like the legal system will just tick on fine, right? And we'll sort of, come up with sort of orthodox legal questions and have those debates and have those types of legal doctrinal responses, and that's all fine. And then what is really happening is somewhere else in the architectural regulation, in the technological management, or in this sort of regulatee kind of manipulation, in a sense. That's where the real action is, and then we might just end up with like the perception in the legal community that everything is just ticking along just fine, when in fact the actual sort of behavioral sort of control and manipulation is happening somewhere else. That I think is the sort of very sort of fundament of legal disruption, and I'm not really too sure what to do about this. This is kind of at the very limits so far as to what I've come up with. So I hope some of this made sense. I hope you weren't expecting a more legal discussion, in a sense. But this is kind of the problems that I've identified and that I would like to sort of share with you, and sort of I don't know, see how we might respond to in a sense. So thank you very much for your attention, and I'm really looking forward to the Q&A. I hope it's not just questions and answers, but actually a proper discussion. Please, feel free to critique my ideas and my work. That's how it gets better, how it gets stronger, how it gets more targeted. So don't hold back. Just sort of speak your mind. But yeah, thank you so much.
Yes, thank you, Dr. Liu. We have 73 participants here, so joining us online. So we have a Q&A box at the bottom of the screen. So I would now invite the participant to just submit your questions through the Q&A box. And I noticed that one participant has already submitted one question. And of course, the other participants are most welcome to just type your questions and send them to us. And I'm sure Dr. Liu will answer all of them. So yes. Now there's one question in the box. So yes, Liu, can you open it? Yes.
Yes, of course. Thank you very much, Freya. So could we use ecosystem thinking as a framework for AI applications? I guess, and maybe you could help me clarify what you mean by this. But so do you mean ecosystem in terms of like a sort of ecologic view in the actual ecosystem term, or do you mean it in terms of ecosystem as in how the sort of tech community has hijacked the term? I'm guessing it's more the sort of environmental ecosystem approach, and my response is exactly this, right? So I think you're right. It's a sort of systemic view where there's a lot of sort of interactions between everything, and it's not behavior as such. It's emergent outcomes, as I mentioned before. So let me frame it a different way and see if this is a good response, right? So if you read science fiction or speculative fiction, however you wish to call it, oftentimes it's very much a recognizable world, and then you have like one technology or one capability or something like that, and it's about the intersection between that one technology, capability, whatever it is, with our sort of our currently recognizable world in this sense, right? And a lot of scenario planning is built around this as well, right? So what if we had X, right? What would happen? And then you kind of go into this sort of brainstorm mind mapping kind of, right? But I think that again is very much a sort of an easy way of thinking, because it's not just one thing, right? It's not just like, oh, you will end up with one AI application or something like that. But the base technology upon which this is built will lead to different types of applications, different types of possibilities, right? And not only that, but it's so for example, AI would intersect with biotechnology, would intersect with all sorts of other things, and so the world fundamentally will be different than just adding one kind of technology into the mix and kind of it's not a single ingredient at a time. And those interactions, I think, will lead to a very different kind of world where it's not really possible to predict what will happen, obviously, but then also it's not really sort of in a legal kind of mindset where it's like this one thing. A slightly different way of putting it is that even in the legal sphere, you inject AI into to interface legal doctrine, and then you end up with all these different kinds of problems, challenges, opportunities, whatever you wish, right? Like those intersections. And so as a result, I think that the ecosystem, or systemic at least, complex adaptive system way of thinking is a better model, but one that also locks out legal discussion. I don't know if that responds to your question. But yeah, please do feel free to follow up. Okay. So I've got Brian. Thanks for. I don't know if you can see these questions and answers, so I'll read them out. So Brian says, thanks for the sharing. I believe we all tend to be anthropocentric by nature and have some thoughts on your framework. But to phrase it as a question, there's an argument that the common law does address your final two categories with the concept of undue influence or state of mind. Okay, so Brian, I have to say that I'm not particularly sure about the sort of limits or precedents involved with undue influence or state of mind. But it seems as though, okay, yes, there are ways of sort of suggesting that there are sort of external influences that come in, affect the decision-making processes, and so forth, and somehow it's separated, right? And so my response is that, well, it's that presumption that underlies this common law kind of positioning. I think that's the problem. It suggests that there's a difference between what is in your mind as is, so as a sort of hermetically sealed kind of entity, from external influences, and that there are sort of influences that are okay or acceptable, and ones that are sort of coercive or manipulative or something like this. What I'm trying to say, and what I think Anil Seth's work does very nicely, is to suggest that there isn't this kind of neat demarcation between sort of your state of mind, your mind, and external influences, but that there's a constant flow between the two. The mind projects predictions, and the perception or sensory input kind of calibrates or anchors those perceptions in reality. And so the way I see the common law doctrine, without knowing anything about it, is that its presumption is wrong in a sense, or at least doesn't reflect the state of contemporary state of cognitive science research. And so I think that this is part of the problem, is that the influence itself, it's not just influence, it's just a way of manipulating people constantly, because that's how sensation works. But I'd be interested to continue the conversation, and I hope that responds well to you, Brian. So someone who's anonymous says, Dr. Liu, would you mind elaborating on the possible alternative forms of regulation outside of the framework of law? Thanks. Okay, so part of what, so I guess what I would sort of lean back on is this idea of sort of, okay, so law is a normative way of regulation, right? I'm going to lean on Larry Lessig, right? So he came up with sort of 4 regulatory modalities, and I'm sure it's not exhaustive, right? So you have law, you have social norms, you have market, and you have architecture. Law, normative, top down; social norms, normative, bottom up; market, incentives, disincentives, like economics, essentially, and architecture code, which is kind of like sort of setting physical kind of constraints on your environment. What I would like to suggest with Larry Lessig's model is that he posits it as the pathetic dot, right? So the regulatee is this kind of pathetic kind of entity that just kind of gets knocked around, sort of like a billiard ball, right? Just gets knocked around by sort of forces. What I think Larry Lessig is missing is that actually the regulatee has its own sort of drives, motives, stuff like this, right? And so it rather than being this passive entity, it has this internal world, which is then subjected, or possibly at least, to different types of manipulation. So rather than affecting, like a billiard ball model where you have to use an external force to knock it on, you could actually manipulate the inside to make the regulatee behave in a different way. I think the closest that Larry Lessig gets to it is this market. It's this market modality, right, where there are sort of different incentives, different sort of punishments, and then like the regulatee kind of tailors its behavior accordingly, so something like this. But I still think that's missing. So I'm not too sure if that answers your question, but basically, like alternative forms of regulation is like, instead of doing normative signals, which is leaky, sort of contain them in an environment that you can control, or contain and control the sort of motivations, and actually manipulate the behavior of the regulatee directly. And I think that this is what new technologies now enable, which is why I'm kind of rather worried about this. But yeah, so law is leaky. Well, why not do something else if you're really interested in affecting human behavior? Okay, so we have Anne. And this is a fascinating talk. Can I ask whether you think there should be areas that we should not engage AI applications? For example, bail applications. With human judge decisions, at least judges need to spell out their reasonings. But with AI, the actual reasoning seems to be in a black box. How can we overcome issues of fairness and accountability? Or would you suggest a better way for human AI collaboration? Okay, so one of the things that the AI sort of like the proposed AI regulation in Europe works is that it's done on this risk, like this sort of risk and restriction kind of framework, right? So there should be AI applications. If they're extremely risky, then we should prohibit them, or outright, so on and so forth. So it seems like you're kind of spelling out this kind of thing, where there's certain types of applications that are just simply beyond the pale, right? And so part of what I'm wondering is, okay, but this is a very, well, this is the European way of looking at it apparently, but it's also a fairly leaky way of doing things, right? Because if you have the base technology, if you have the base capability, the application is very straightforward, right? It's like essentially like a dual use or multi-use, as like military people might term it, right? So for example, like a navigation system, right? A navigation system could be used for an autonomous vehicle. It could be used for flying drones around. It could also be used for military applications, right? And it seems as though like once you have that base technology, kind of trying to clamp down on certain applications is extremely difficult. So that's the first thing that I would like. But what are you saying in terms of human judge decisions? I'm not too sure that now I see the distinction between human judges and algorithmic judges, right? Humans are black boxes, right? Like I don't know my motivation for for like, I don't know, doing this talk or for thinking the way I think. Like I don't have control of this and I don't have access to this. If you ask me, I can tell you something. But psychologists, would say that there's a strong possibility for confabulation, right? So your system one does something, and then your system two, your rational thinking, so just kind of justifies it, and the two may simply not be connected. So I mean, I would actually suggest that humans are also black boxes, and that we have a general problem in terms of decision making and fairness and accountability, transparency, all of these things. There's a very famous the very famous study coming out of Israel. I think parts of it have been discredited, I'm not sure, but it correlates the sort of severity of probation sentences with the sort of time period from the judge's last break or mealtime, right? And there's a strong correlation between sort of, like distance from judge's last feeding or break to the severity of the sentence, right? So, like sort of before lunch, it gets really severe, and then after lunch, it gets more lenient, and so forth. Like I say, like the study has, I think, not necessarily been discredited, but it's been challenged. But I mean, sort of, like a very sort of like human empathetic kind of experiential kind of way of thinking about it. Like you can relate, right? Like you kind of, feel more frustrated or something like this before meal times, things like this. And so like I would actually suggest that human judges under this setting are actually less consistent, and if decision making and consistency are two different are sort of things that we value, then I would actually suggest that human decision making is maybe not the way to go, right? At least you have consistency. There's a lot of fascinating work from Daniel Kahneman like about this, where you present the same person, the same case in like across different times, and they will come up with a different answer. And it's just like, if there's no consistency, then I think that there's a problem there. So I don't know if that's a way of answering or responding to your question, but those are some of my thoughts. Okay, so Freya again, is it possible, still considering the complexity of our reality, to still hold on to disciplines, or can we really only address it by a transdisciplinary research? Thanks. Okay, so I think it's an excellent question, and so I guess what I'm trying to say is not necessarily that we ditch disciplines. Well, I mean, I would like to say this, but I mean, I realize that then the full complexity of the world becomes overwhelming, and we can't really meaningfully study anything without compartmentalizing it and putting specific methodologies and frameworks in place. Like I understand that. So I guess what I'm trying to say is not necessarily let's throw everything out and start again. What I'm trying to say, I think, instead, is that, well, okay, fine. Like legal processes have been around for a while, and like they're suboptimal for sure, but they do, they have been able to sort of, soften the edges of human interactions, right? And as a result of that, there is value. I guess what I'm trying to push back against a little bit is more that there's this sort of this kind of almost how would you say it? Like there's a presumption that the law is somehow comprehensive and should cover all areas, all fields of human activity. And that to me seems a bit, that seems to be the problem, right? It's a sort of like, I think the law should realize, the limits, its own limits, right? In terms of, okay, well, okay, so if it's a normative thing, we can deal with it. If it's about coordination, so like, are we driving on the right side of the road or the left side of it? It doesn't really matter. It's a coordination question. Fine, leave it to the law, right? But where it comes to sort of like other kinds of issues, where it sort of does deal more with the complex, like the full complexity of the world, then maybe we should lean on other disciplines and not sort of transport or like transpose sort of legal thinking into other areas, as it were. So I guess a different way of putting it is that like the legal discipline seems to be one where its doctrines seem to be immutable somehow, right? It's sort of like a different example is neuroscientific research and the criminal, right? There's a fantastic amount of work about this, but somehow like the criminal law sort of presumptions of intentionality and everything to do with mens rea seems to hold, and it's sort of like we have these insights, like empirical insights, and it doesn't match this doctrine. So we push back against the empirical stuff rather than wait, maybe we need to change the doctrine or even how we approach this thing in the first place. So I think that's it. Freya again, thanks for your answers and thinking. I was wondering, should we perhaps leave law to regulate humans and think of something different and radical to regulate AI? Some argue that we should enable AI to have rights and responsibilities, and, for example, be able to own property, which could be used if it causes harm to pay for it. Interested to hear your thoughts. I think so. I would like I'd like to agree with you, but I think it's the exact opposite way, which is what's happening, right? So we've actually left AI to regulate humans, and I don't know if AI is actually being regulated beyond sort of what is currently possible or economical to do, right? So what do I mean by this? Okay, so like AI is regulating humans. We just don't call it that. We just think of it in different terms. I guess I've been harping on about this for a while, so I'll push that aside. So you say that, okay, so we should enable AI to have rights and responsibilities. That's fine. I don't particularly have a view on this, but what I would like to flag up is that this is exactly that kind of orthodox thinking, right? It's just like, okay, we have this new entity, right? And it persists between agent and object, right? It's in this kind of liminal space, and we take it and we give it, okay, it's now a legal agent, right? And that can potentially resolve many of the legal problems, right? So like rather than sort of going in and saying, oh well, actually AI is responsible in this kind of scenario but not in this context, it can enjoy IP rights but not sort of human rights, or like stuff like this, you could just say, okay, it has personhood, boom. Sort of like recognition of like corporations, for example, or international organizations, stuff like that. Give it legal personhood. That would solve things. So I think the thing is that kind of response is great because it gives us predictability and legal certainty into the future, and sort of brings AI applications back into the fold, right? In a sense, I think it's perilous because then it sort of it concretizes one way of looking at it, right? One metaphor, right? So AIs are now agents, but what about this complex adaptive stuff that we were talking about before? Like what happens if it's a network, right? Stuff like that. And so it concretizes one metaphor or one way of thinking about it. And it also, I think, dispels a lot of these other kinds of issues, right? That I've been talking about, right? So the idea that AI might actually be a regulatory tool that is sort of somehow outside of legal thinking. So to me, it seems like on a day-to-day basis, right? Maybe do that, but keep this sort of background thoughts in mind. Okay, so we have Ron. So the question is, do you have any thoughts on liability and its apportionment? The problem with AI models and their acts are these are hard to model. There are elements of unpredictability, and humans are likely to bear some responsibility both for the model and the input data. Okay, so actually, this was one of the ways that I actually got into this area in the first place. And so let me give you a concrete example, which I worked on, and you can find it in my publications. It's called Refining Responsibility. It's a book chapter from 2016. And so fundamentally, the idea is in the context of autonomous weapon systems, you have this weapon system that once once activated can select and engage its own targets without further human intervention. That's the idea. And so then then okay, it goes and does some horrible war crime, something, right? Who's responsible? Then you can trace it back and you can say, well, the operator is responsible, right? Because like the operator failed to do X or Y, right? The commander is responsible, failed to do X or Y. The programmer, etc., etc. So fundamentally, the problem I found here is that the legal concept of responsibility and liability is actually this umbrella term that incorporates all of these things that we care about, but are actually fundamentally different. So what do I mean by this? So there's the difference between causal responsibility. So the autonomous weapon system caused the atrocity, right? And there's the concept of raw responsibility. What are you as a person in this sort of causal chain responsible? Well, the programmer responsible for making good code that doesn't fail or something like this, right? The commander responsible for preventing and punishing sort of unlawful violence, right? The operator responsible for selecting and engaging in certain targets. I mean, like in the paper, I actually say that there's no such thing as an operator anymore because that's the autonomous weapon system, and you just have a series of commands. But my point is that there's a difference between the causal responsibility, the sort of like the terrible outcome that happened, and what each human, each proximate human, I called it in the paper, is responsible for, right? They're just responsible for doing a good job. And so I guess what I'm trying to say is that each person in this chain is responsible for doing a good job. And insofar as they're liable or responsible, they're only responsible for having not done a good job, but not responsible for the actual outcome in a sense. And so there's a fundamental disconnect when it comes to something like AI, that there can be terrible outcomes, and that people along the way have kind of done everything that they could have done or should have done, mainly should have done, right? They fulfilled their roles, they fulfilled their obligations, and so they're not responsible for the outcome. And even if not, they're not responsible for the actual outcome as such. That to me seems somehow very unfair, and like you say, it's very unpredictable, right? So this unpredictability, people aren't usually kind of made responsible for. So those are my thoughts on that. I don't know if I think that's it so far, right? Am I right, Felix?
Any other questions from the audience? Yeah, please feel free to submit your questions. Well, perhaps I can ask a question. And
please.
yes, you have articulated your criticism against the doctrinal approach to accommodate the emerging technologies. If I understand your argument correctly, this doctrinal approach can be very fragmented. It could be largely technologically focused or domain specific. And are you advocating a more holistic framework instead of this fragmented approach? So I would like to hear your views. The second, and if your holistic framework is to be adopted in Hong Kong, which is a common law jurisdiction, to what extent is it compatible with a case law system? Because our doctrines, the legal principles, are largely embedded in different judgments on a case-by-case basis. So I would like to hear your views on that.
Sure. Okay. So I guess responses. Okay, let me back it up. So AI seems to be this like a sort of foundational technology, right? So it's sort of like electricity or like something like that, right? You can build many different things upon it, right? And so part of my concern with a sort of with a sort of siloed response to something like AI is that you'll end up with doctrinally inconsistent responses like across the board, right? So for example, like in the field of IP, they might recognize like AIs as beneficiaries or holders of IP rights, right? And that seems to be okay. Well, wait, that's more of a sort of human agent kind of thing. But like with AVs, it might be like, oh well, they're never responsible, right? It's always something else, right? And so part of the problem is I think that the responses to AI applications, if left to the applications themselves, could lead to very sort of inconsistent or even conflicting kinds of responses, which then causes which undermines legal certainty and predictability, all of the things that we need. But more than that, sort of discredits law as a system as such, because if you can't hold a sort of coherent sort of response, maybe that's a problem in a sense. But it's also from the way I see it, it's also much more efficient to sort of tackle it at root, right? So okay, if we choose to model AI as something between agents and objects, right, and we just kind of choose a position on the spectrum, if you make that choice and it percolates through, much easier, right? So you have consistency and efficiency, right? But of course, this conflicts, like you say, with the common law system, where what was it, like sort of Alan Dershowitz, this kind of idea of rights from wrongs. You need something wrong, and then you respond to that, and then a right emerges. It's not like a principled thing. And so how do you do that? So I guess what I would suggest would be something along the lines of, like set forth like a how would you say it? Like set forth a way of like almost like a policy document or something like that. Okay, so like we understand AI to be, I don't know, more like a human agent, something like this, right? And based off of that, then the judgments can kind of come forward, right? So sort of almost coordinate a response in terms of what you position AI applications or how it's treated, and then when the wrongs come, as it were, or when the claims come, then the judges can kind of based on, okay, this is the sort of societal position, then we can choose. And what you say about Hong Kong, right, is also interesting, because it's like Hong Kong can take a very different position than other common law jurisdictions, right? And so there is a way also of sort of tethering it to a regional context, right, or a particular jurisdiction that makes sense for the jurisdiction, which doesn't necessarily need to apply elsewhere. So that's the kind of thing that I would suggest. Of course, the judiciary would be like, well, what you're constraining are kind of liberty and freedom. This is not the point of this separation of powers. So I haven't worked that out yet, but it's just responsive.
Yeah, maybe one last question from Mr. Brian Tang. He has just submitted his question before we conclude the seminar. Yeah.
Okay, so Brian says, thanks for your responses. Quickly looking up Seth's work, it seems to be based on formulations of consciousness and also on identity, which may limit its utility for analysis of responsibility and culpability that are central to the law's role in dispute resolution. Right. Okay. Yes. Yes. So Brian, I think you've got like my ideas like spot on, right? And so it seems as though like law would have a role in dispute resolution, or in terms of coordination, or just kind of like societal lubrication, in a sense, like just getting society to work. I guess like that whole sphere of things makes sense, and I think that the law should carry on doing this, right? I mean, that's what it's been doing, and it's kind of it's muddling along, and it's fine, right? I guess my sort of focus in bringing up like Seth, and also how that connects with AI and XR, is that there's something else going on. So you're exactly right. It's based on formulations of consciousness, and also the formation of identity, of being you, as the title of this book is, right? So it's about who you are, and I think that's a sort of pernicious gap, like perilous gap also, because like it's like like these are not legal questions. These are sort of philosophical, theological questions, something like that, right? And but the point I guess I'm trying to make is that it's not necessarily only about consciousness and identity, which would be ordinarily if you only isolated Seth's work. But if you sort of couple it with AI and XR, the possibility for actually sort of changing one's identity, or sculpting the regulatee's identity, right? That becomes a possibility because of the technological affordances made by AI and XR. But and that's obviously a very, very powerful form of regulation, but we don't think about it as that, because we think about, well, wait, law is dispute resolution, it's about coordination, it's about apportionment of rights and obligations, and so forth, right? So it's like these separate kind of conversations, which I think need to be kind of put together. But yeah, I realize we're a bit short on time, so I'll put it off there.
Yes, thank you very much, Dr. Liu. On behalf of the Law and Technology Center of the University of Hong Kong, I would like to give thanks to you for your excellent presentation and your very insightful response to all our questions. And it is our privilege and honor to have you as our distinguished speaker. And of course, we look forward to listening to your talks again. Perhaps it could be arranged in the future.
Sure.
So we definitely want to have you as our distinguished guest speakers again.
Okay, thank you so much, Felix. And yeah, like I very much hope that this is a sort of beginning of a conversation and collaboration. But thank you very much for sort of I guess taking a risk on having me come and throw these kind of crazy ideas at you. So thank you so much.
Thank you very much, and of course, thank you to all the participants who have joined us online and all the questions that you've raised. And we will have more talks organized by the Law and Technology Center in the future. So please, we will keep you updated through our website. So the information, the details of speakers will be posted on our website. So please stay in touch with us through our website as well. So thank you very much. So I look forward to seeing all of you again. Bye.
Thanks. Bye.
Thank you.
Bye. Thanks.